I just start with a quick karakia, and I'm sure you've heard it all before. Whakatakata hau ki te uru, whakatakata hau ki te tonga, kia mā kinekena ki uta, kia mā taratara ki tai, hei hiake ana te atakura, he tio, hei huka, hei hungahanga, ti hei muri ora. So it's really nice to see all your faces here. I'm Mike Dickerson. I can be found at the website rove.wiki, and I am a freelance Wikipedia consultant from Christchurch and now living back in Christchurch. Previously, I've been a science communicator, a museum curator, a digital librarian, and now I am a Wikipedian. So I have been doing work with several different scientific organizations, including Our Land and Water, which the impetus for doing these lunchtime seminars has come from that project. And now it's more of a collaboration between Shared Science and Annabelle and me. And if these sorts of things are successful, I'm sure Shared Science would be keen to host more such informational webinars in the future. So what we're going to focus on today is the New Zealand copyright laws, which is instantly a snore-inducing topic, but we're going to try and make them directly relevant to you folks and your job. And I will run a sort of quick overview and crash course via slides for about 30 to 40 minutes. And feel free to interrupt with your mic on if there's something that completely has gone over your head or I've used a term that does not make sense at all. I'll stop and quickly explain. If you have a more in-depth question or a pressing use case that you need clarification on, make sure you make a note, and we'll have at least 20 minutes of discussion at the end of the talk in which we can talk through all of our different scenarios. So, without further ado, I'm going to share my screen, which will take a section. I think that's the right one. Okay, and could someone with their mic on tell me if they're seeing this screen? Oh, copyright for scientists. Oh, there's a thumbs up. Oh, I love the thumbs. Probably most of you haven't used Whereby before, but it's a lovely little online video conferencing app from Norway, of all places, that is a very simple interface, does not require a login, and just hosts open chat rooms. So go give them money if you want a lovely little video conference tool that's not part of the video conference industrial complex. Okay, so here we go. This is a talk. I've given something similar to this last year to the staff at the University of Otago Biology Department, but you guys are the first to see it in its current form. Right, so we're going to be talking about copyright today, and we're going to be specifically talking about the New Zealand Copyright Act 1994, which is what affects you folks. It's really important to note that copyright law differs quite a lot from country to country. And if you were just searching on the internet for information on copyright, you are going to get predominantly American advice. And America has very different provisions in its copyright laws than we do. So you could be badly misinformed. So just bear that in mind. Also, the Copyright Act in New Zealand is desperately in need of reform and will probably be radically changed in the next few years. Certainly one big change is that the duration of copyright in New Zealand is going to be extended from 50 years after death to 70. We'll talk more about that later. Now, it's also worth noting that you should check your contract of employment to see if you have any provisions relating to intellectual property or copyright, because there are some laws in New Zealand that might affect whether the work you do on the job is your copyright or belongs to your employer. And it's perfectly possible to have conditions in your contract that specify, oh no, I still retain my own copyrights for a book I write or photos I take as part of my job, but that's going to have to be in writing somewhere. And you could get a nasty surprise one day if there's a misunderstanding on who actually owns the copyright of work you've done. So the sorts of copyright that we're looking at is encapsulated by these photos here. So the first one is a 1941 photograph from Lincoln University's teaching collection of harrowing a field, taken by the staff photographer there at the time, and that's clearly the copyright belongs to Lincoln University because it was a staff photographer. And you can see CC by 3. That means it's been released under a Creative Commons license, version 3, not the current version, which means anyone can reuse that photograph as long as they credit Lincoln University. And the next one is a piece of public sculpture in Palmerston North. Now, that is a copyrighted work, even though it's a three-dimensional artwork in the public sphere. It's not in the public domain, which is a completely different technical term in copyright. But I was allowed to take a photograph of it and use it on this presentation without asking permission, even though it's a copyrighted work. That's because New Zealand copyright law has exceptions for three-dimensional public artworks and architecture, which means that ordinary tourists can take photographs of sculptures and post them to their holiday slideshows without infringing anyone's copyright. This is a very specific provision of the copyright laws that not all countries have. And the third one is a piece of street art in Wellington. Because that piece of street art is not a three-dimensional public sculpture, it is, even though it's in a public place, still protected by a New Zealand copyright law. And it's copyrighted the artist, Mika Still. Mika was painting it, and I asked her for permission to photograph it and use it in the slideshow. If I hadn't done that, then I would be violating the Copyright Act 1994. Now, that might seem very minor, but what if I'd made a calendar or a postcard or a t-shirt with her image on it and sold it commercially? Mika would quite rightly be outraged, and she would have very, very good grounds for making a case against me under the Copyright Act, because even though that painting is in a public place, it's not in the public domain. It's not freely available to share and use because of the specific conditions of New Zealand copyright law. So those are three different examples of visual images that are all protected by copyright and all reused in different ways. And you can see, I think, how easy it would be to get into trouble or to get crossed wires or miscommunication with a co-author or a student or a friend or an employer if you both did not have the same understanding of copyright and reused things in a way that the other person didn't agree to or didn't know about. And that's why we're having this talk today, is so that you will get a crash course in New Zealand copyright and see how it affects your work. And as a bonus, we're going to talk about a way in which you very often have to sign over your copyright to someone else and give away your work, but there's ways in which you can retain some ability to keep reusing your work without necessarily having to go for permission each time. So that's a little technical thing that we're going to give you as a bonus for attending this. Right, so let's go through the difference between copyright and licensing. Two separate things, often confused. People get these mixed up all the time, and you actually have to be aware of both. So today we're going to talk about copyright, which is literally what it says on the tin. Who owns the right to make a copy of that work without having to get permission or anything? Who automatically has the right to make a copy of a work? And then you can also, as well as if you own that right, you can also license that right. You can give other people permission to make copies temporarily or permanently or for some purposes but not others. That's called licensing, and that's a whole topic on its own. So under that Lincoln University photo where it says CC by 3, that's a Creative Commons license, and you can apply that to any work that you own the copyright for. You can choose to give it away under a restrictive or non-restrictive license to enable it to be more reused. And because we're mostly working in science, the goal of which is to make sure our results are shared and used as widely as possible so people know about them, we should be very interested in how open licensing might work. And that is the topic for the webinar in 2 weeks' time, Open Science and Licensing. So feel free to sign up for that. We were not going to go into great detail about things like Creative Commons licenses today. We'll briefly touch on them. That's for the next seminar is going to be just about those licenses, how you use them, apply them, and cite them properly. Okay. Right, you are now going to have, buckle up, a crash course in New Zealand copyright. Okay. And we're going to go through, and I could have split this between 20 slides, but I decided I would just put this all on one slide so that you can learn, memorize, maybe I'll send you all a screenshot of it, the absolute key facts that you need to know to understand New Zealand copyright law all in one place. Now, there's also a handout which summarizes these things, which I've sent to you all as an email about 20 minutes ago. So unless you registered at the very last minute, you should all have a handout with that information too. But let's go through it. So Copyright Act 1994, New Zealand. Okay, first thing is copyright happens automatically. You don't need to register a copyright. You don't need to use a special symbol, like the copyright symbol, to make your work copyrighted. It's granted to you these days, did not always used to be the case, but certainly today, since the 90s, copyright's automatic for creative works. Right, what is a creative work? Well, you have to have created something with a sort of minimum threshold of creativity. Something that's generated automatically. Slapping a photograph on a scanner and pressing scan is not considered an act of creativity. It's just duplication. But if you took that photograph and tweaked it and cropped it and adjusted it and cleaned up the problems with it and maybe put a new color cast on it, maybe modified it a little bit, you're starting to approach a threshold of creativity where you can distinguish your creative work. Now, famously, one of the copyright people I know says that if you do a scribbly doodle on the pad beside the phone, congratulations, you've created a copyrighted work. And so the bar of creativity is actually quite low, purposely set that by the big companies who are very, very much like copyright. So pretty much any creative work, that's something you write, something you record or film, a photograph you take with your phone, is a copyrighted work. So we are all creating copyrights every day. Every email we write, every photo we take with our phone is a new copyrighted work, copyrighted to us. This did not used to be the case. People in the olden days did not make a lot of creative work, and you were a very specialized person if you created something that was protected by copyright law, a professional writer or an artist. But today, we're all copyright creators. Oh, there's a chainsaw going on in the background. This is going to be fun. Okay, so copyright's automatic. Everything you make is copyrighted. It's copyrighted to you, and it's protected by the full force of copyright law, which seems somewhat overkill, but that's the case. Now, copyrights do expire. They don't last forever. They used to last for 28 years, for example, and gradually, in the 100, 200 years ago, and gradually that term has been increasing and increasing. It never goes backwards. It always gets longer and longer. Currently, under New Zealand law, your copyrights expire 50 years after your death. And that continues if you move the copyright, you hand it over to someone else or pass it on, it's still going to expire. That 50 years after death is actually a little bit low now on international standards. Most Western countries have gradually inched it up to 70 years after death. And as a result of a couple of trade deals that were recently signed, New Zealand is now going to synchronize, is going to match those other countries. This was actually tremendously controversial. None of the creative sector who would be affected by this were consulted in this choice. It was just handed over as part of the EU agricultural trade agreement as a sort of bauble to help sweeten the deal. And now we have to rewrite New Zealand copyright law very quickly to synchronize with that term. But anyway, 50 years after death, though, is still a very long time. So if someone wrote a poem in their teens in 1925 and they are still alive today, which is entirely possible, then their work is still going to be protected for another 50 to 70 years, which is like 150 years after they did the creative work, which is an extraordinarily long amount of time. And we're constantly coming across cases where a work that we thought was out of copyright is still actually within the 50-year window after someone's death. Because of that, if we want to reuse that creative work, if we need to get permission to reuse that work, we need to find who the current copyright holder is. Obviously, it's not the person who's died because they're dead. So it's passed on to someone else. Whoever has inherited that person's property has inherited their copyrights, usually. Copyrights are almost never specified in a will. Copyright law is really actually set up for the benefit of large companies, multinational corporations. It's not actually very sensible when you look at it from the point of view of an individual, and yet here we are all creating copyrights. So this creates real problems where we have a work that was created by someone who died 30 or 40 years ago. It's impossible to find who the copyright holder might be now. They could have died with no known descendants, yet someone still owns that copyright. God knows who, and that work is called an orphaned work. And that is a real problem. If you're dealing with a lot of historical objects, then the problem of orphaned works is really noticeable, because even particularly in America, where the copyright terms are even more onerous, you can have work that essentially is unshareable or unreproducible or unusable by anyone for 50 or 60 or 70 years, because it's not clear who it is we could even ask for permission. And yet it is still protected by the full force of copyright law. So we do have a provision in New Zealand's copyright law that photographs that at the time of the law was signed, work that was taken over 50 years ago was deemed as out of copyright, and that work was signed in 1994. So anything taken before 1943 is definitely out of copyright in New Zealand. So that's photographs here. So if we look below, we'll see that the 1948 photo by Ron Blackmore, I got the date wrong, sorry about that, was copyrighted to Lincoln University. Why it's taken by Ron Blackmore, but Ron Blackmore was an employee of the university. So he is not actually the copyright owner, it's copyrighted to Lincoln. But Ron Blackmore did not die that long ago, and so his work is still in copyright, and even if Lincoln is the copyright owner. But another photo that he took in 1934, the copyright has expired because of New Zealand copyright law. So the pre-1943 ones, the copyright has expired. The way we technically credit that is we say no known copyright, and that as far as we know, this is uncopyrighted. It's a very weaselly way of saying yes, the copyright has definitely expired. It's very hard to think of a circumstance in which that could possibly be in copyright, but the institutions tend to just say no known copyright. If you see that, that means you are free to reuse that photograph for any purpose you like, commercial or non-commercial. You're not even required to credit the photographer. You can do whatever you like with it. Its copyright has expired. So that is luckily a situation for works taken before 1943, but in the USA, for example, there's no such nice provision, and in fact they're only just dealing with work that's from 1928 that's come out of copyright, because their effective copyright term is much, much longer than ours. Now, another thing that's different between New Zealand and the USA is in the US there's a concept of fair use. And this is why I said looking for copyright information on the internet is a bad idea, because you'll get someone talking about, oh, this is you reusing this under fair use. That's a specific provision in United States copyright law. What fair use means is that, yeah, you can reuse this, mostly if it's not completely cut and dried, but if you're not doing it for commercial purposes and you're not doing it in a way that's going to leech away the rights from someone else, and maybe you're just using a low resolution copy of it and you're not making lots of copies and so forth. There are a bunch of different qualifiers that if you tick most of those, what you do is considered to be fair use, and thus you're exempt from the usual copyright statutes. There is no such provision in New Zealand. There is a fair dealing provision which mostly applies to places like libraries and archives, and allows for the reproduction of certain portions, certain works for certain purposes, or certain portions of works for teaching purposes, and agreements that are worked out with those teaching institutions and libraries. But that is not something that applies to most of us in our daily lives. So we don't actually have an ordinary fair use provision in New Zealand. And what that means that even things like parody, for example, if you were to do a satirical song about a politician, we don't have any copyright exemptions for parody in New Zealand, so the copyright owners of that song could request that you take it down. So we have some problems with our copyright law in New Zealand, and that's the supposed incentive for a reform of our Copyright Act. But just bear in mind that reusing a work, whether for commercial or non-commercial purposes, it doesn't matter in New Zealand. You will still have to pay attention to copyright. You can't say, oh, we're a non-profit. Oh, we're not making any money for this. Oh, it's a good cause. Oh, I'm only making a few copies. The only exemptions we have are actually for personal, private research or education. So making copies of things just for your own use and not sharing them with someone else is considered okay under the Copyright Act. But as soon as you start sharing copies with other people, you don't have any of that protection. And another interesting thing is the difference between owning a physical work and owning the right to make copies of it. So if you bought a Colin McCann painting or something, or indeed a creative work by any artist whatsoever, a photograph, a sculpture, a print, even a hand sketch or a doodle, and framed it and put it on your wall, you've purchased the work, the physical work from that artist, but you haven't probably purchased their copyrights from them. That would be quite unusual. Most institutions that own paintings, professional art galleries, when they purchase the painting, they usually did not purchase that copyright from the artist. The National Museum of New Zealand did act. The National Art Gallery did for a while in the 60s, which unusually, but most institutions, if you own a work, a physical work, it doesn't mean you own the copyright. So if you tried to make a postcard of that Colin McCann painting on your wall or a t-shirt, you would actually have to apply for permission to do that from the copyright holder, which is not Colin McCann because he's dead. It's the Colin McCann estate. The Colin McCann estate would probably want you to pay them a large sum of money because they're quite protective about McCann's copyrights, and it's a good income source for them. So just the ownership of a photo doesn't mean you own the copyright. How does this affect us? So a photograph of you, for example, you don't own the copyright of that photograph of you unless it was a selfie, because you did not push the button on the camera, and thus you did not make the creative act. The photograph was probably taken by someone else, and that makes them the copyright owner. So even if it's a photo of you, even if you own the photograph, even if you own the only print ever made of that photograph, you're not the copyright owner. And so if you wanted to reproduce that, put it online, even use it in a PowerPoint show, you would need to get their permission. And this is something that trips people up all the time in New Zealand, because we have another issue here, is that if work is commissioned or made on the job, just like the Ron Blackmore photograph below, just because Ron Blackmore pushed the button on the camera, that doesn't make Ron Blackmore the copyright owner. The employer, Lincoln University, owns the copyright. And this is a big issue particularly for large collaborative science projects, where you're trying to share graphs, charts, maps, or photographs of your work. Who actually is the copyright owner of those? You can come to the end of a very large science project and have a whole bunch of photography that you want to share in a paper or in a public talk, and you have to try and figure out who actually took those photos, and were they doing it in the course of employment, and what does their contract say? Who is their institution the copyright owner, or were they the copyright owner? Was it taken in their free time in the weekend? Was a professional photographer brought in to take those photographs? What does the professional photographer's contract say? Because despite point 6 here, most professional photographers in New Zealand put a clause in the contract, in the paperwork that you have to sign, that says they will retain the copyright of all the photos they take, despite what the Copyright Act says. And they're entirely able to do that. But what that means is that if you want 20 years later to publish that photo in a book or a report, you have to track down that photographer and get their permission. And possibly, if they're awful, you'd have to pay them again. So wedding photographers love to do this because they want to be able to charge for the wedding photographs multiple times, again and again, to different people. So I would recommend, my advice to you is if you engage in a contract with a professional photographer, check the contract fine print and see if you can negotiate to keep the copyright of the work that they do that you're paying for. That may not be, and generally photographers professional associations advise them and even give them draft contracts to say that, no, here's what you need to put in your contract to keep your copyrights. You need to negotiate with them about that. If they refuse to budge, consider finding a different photographer, because the long-term usability of the photos that are taken are probably far more important than the creativity of any individual photographer. It's no use having wonderful photos if you can't actually ever reuse them again. So that's the 6 points. That is now a crash course in New Zealand copyright. All of these are important to consider if you are a practicing researcher dealing with any creative work. And that can be not just a photograph, but a diagram or a graph that you make, any piece of text that you write, whether it's a press release or an email or a passage in a scientific paper. Someone is a copyright owner of all of that work. Okay. Now, I'm just going to introduce you to a site called Wikimedia Commons. Wikimedia Commons, and we'll see why this is important in a second, is a repository. It's a parallel project to Wikipedia, and it's an open image library. Anyone can upload a photograph to Wikimedia Commons, or a sound recording, or a piece of video, or a diagram, or a chart, or a map, or a graph. Any creative audio-visual work can be uploaded there. It'll be hosted for free forever, or as close as forever means on the internet. The only conditions is that the work has to be either uploaded by the copyright owner, or if it's not you're not the copyright owner, it has to be available under an open license or out of copyright already. So this is a photograph of Mason Dury, and that was uploaded by an author called Dave Wiltshire, a university photographer, and that has been released under a Creative Commons Attribution license, which is an open license, which means anyone can reuse this photograph now for any purpose as long as they credit Dave Wiltshire. And they can download it at different resolutions as well. So Wikimedia Commons is a useful place to host photography in particular that you'd like other people to be able to share and use, like a press kit of photos for your talks or for the media. There are other repositories like this that you can host photography in. Now, a problem that often occurs is that when you want to publish something in a journal of some kind, you have to sign an agreement that often transfers your copyright over to that journal. That is, you have to give the journal the copyrights for your text, your graphs, particularly your photographs. And because the journal is now the copyright holder for many decades into the future, if you wish to reuse those images, that text for any purpose, producing educational material, a chapter, reprinting it in a co-authored book, for example, or a textbook, you will have to approach the publisher and get their permission for your own work. Sometimes you may have to pay. It's hard to know, because who knows what in 20 or 30 or 40 years' time Elsevier or Springer will have mutated into. But currently they are reasonably profit-driven. I think I could say that. Extremely profit-driven entities. So they may or may not exist in the future. They may or may not be willing to grant you free access. You might have to pay a licensing fee for every reuse of that work. And that can be a problem if someone wants to reproduce an image from a work. For example, I'm just looking at a copy of the latest issue of the Journal of the Royal Society, which has some beautiful photographs of fossils. That's their special issue. I would love to use one of those photographs in a publication, but I have to now click through and follow the link to Springer's licensing agreement tool, which is automated and which would it would charge me a licensing fee to reproduce one of these authors. Even if the author, the photographer, who I know, said, sure, no, that's okay, Mike, you're welcome to use my photo, but they can't say that anymore, can they? Because they're no longer the copyright owner. Springer is. So there are severe problems with the way in which we are handing over our copyrights to publishers. You can negotiate with the publisher for a copyright exception in the contract. You don't have to sign that. You can talk to, if you have a copyright officer at your institution, a university or a large CRI, you would have someone whose job it is to deal with these sorts of things. Talk to them about it and see if you can negotiate exceptions. It's not always fixed in stone. But let's say you're under you have no such out and you are about to sign away one of your favorite photographs that you need to use in a paper, but you're about to sign the copyright over to someone else. What you can do is you can upload that image to Wikimedia Commons. That is, release it under an open license, because at this point you're still the copyright owner. Now, why would you want to do that? Well, like I've said, Commons can act as an image gallery. You can keep a shared lab image collection, for example, there that anyone can easily get to. You don't have the issue of, oh, who's got those photos? They're on someone's hard drive. Oh, they're on the lab hard drive, but I don't work there anymore. Who can email them to me? Oh, he's on leave. Oh, no, they're on sabbatical. You know, the usual nightmare of trying to get images out of someone. So you've got a shared free repository for all those images. The repository also will really clearly state who the photographer is and who the copyright owner is, and provide some descriptive information. So it's very easy to make sure you credit someone properly. That's never the case when you just email someone a photograph as an attachment. All that information is usually lost, and there's no guarantee that they'll actually be able to find out who the copyright owner is. And the most important thing is that when you upload something to Commons, you're releasing it under an open license, which is an irrevocable open license. It's a legal license that can't be rolled back. So that file is now freely usable by anyone for any purpose, and including you and your collaborators in the media and anyone else. Now, when the time comes to use that image in a paper, you can continue to use it and cite that same open license. And this is perfectly normal for a publication to use Creative Commons open licensed imagery, as long as you go by the conditions of the image, which we're going to talk about a lot more next session, about how you properly credit Creative Commons licensed photographs. The image can continue to be used. And in this case, it doesn't matter if the copyright is transferred to someone else, because the image is already open licensed. So it's an irrevocable license, so you can continue to reuse that work even if you're no longer the copyright owner. So this is, if you can't get the copyright transfer clause cancelled, you can try releasing work under an open license. And one of the places that you can do that is Wikimedia Commons. Another is Flickr. So if you, anyone here, wave if you use Flickr if you're a photographer? No? It's a free, currently probably going to stay. It's been around for a while. It's just to changed owners, but I think it's likely to be around for a bit. A free image gallery repository that photographers use. When you upload photos to Flickr, you can pick a copyright license there. So, for example, you can see that Mike Keen's made this photographs available under those little icons mean a Creative Commons attribution non-commercial use license. So you can choose to use Flickr to publish your photography in a way that other people will be able to continue to use it, and you can continue to reuse it even if the copyright's transferred. The same with observations in a tool like iNaturalist, for example, which is a nature photography and identification tool, which also lets you apply a license to your photographs. So you can see down there the attribution copyright Mike Dickerson. So that's a basic attribution license. Again, if the photo is put out through iNaturalist and it's an observation, then you can freely reuse it even if the copyright's changed. It's also actually, iNaturalist is a really good source of other open licensed photography too from other people. If you ever need a photograph of a New Zealand organism, it's a good place to look. So we've got an option here of releasing our photos under an open license first before we do a copyright transfer. And that way we can still have free reuse of them even if someone else becomes the copyright owner. Now the big question I get is, what about if I upload some special photograph, like this is a species, for example, that was about to be described in print, and the photos were uploaded to Commons. The author was really worried that the photos could be scooped. Someone else would see this new species and rush off and describe, which happens more often than you might think. Might rush into print with a new species description and get all the credit. These happen. I mean, actually, this is mostly imaginary, but sometimes this does actually happen. It's perfectly possible for you to release photos with or graphs even, or maps with quite generic metadata attached to them, such in a way that they're even a bit cryptic, but the image itself is still open licensed. Then when the paper's published, you can go back, add better metadata, and put a link into the paper itself. So if you're concerned about being scooped, it's quite okay. There are ways of releasing imagery under a more open license and saving yourself the issue of copyright capture. So that's just a little tour of how copyright can affect you in daily life, and how there are ways of using licensing to get yourself out of some of these pickles. But I would like at this point to take some questions and turn off sharing. And the summary here, including the details, in a Google Notes document, which I've shared with you.